Welcome back. Did the answer to the previous question surprise you? Many people don't realize that they own intellectual property. As I mentioned earlier, intellectual property is complex. The Copyright Act of 1976 made copyright automatic without needing to register your copyrighted work, so long as it's fixed in a tangible form of expression. This act brought U.S. law into compliance with the Universal Copyright Convention developed by UNESCO in 1952 and enacted in Geneva. Everything from doodles in your notebooks to essays written for school assignments to pictures taken on your phone to full books are automatically protected under U.S. copyright, regardless of the country in which they were originally produced and the status of publication. I believe it is safe to assume each and every person enrolled in this course has some copyrighted work, if not ownership of some other type of intellectual property. Of course, not everything is copyrightable. There are limitations to what can be copyrighted, and we'll get into those later. But for now, we'll cover the basics of intellectual property more broadly. You probably picture something when I mention property. Maybe it's a car, a house, land, the school supplies you have on you, or money. Most types of property are physical. You or someone else owns that physical item. Intellectual property is different in two primary ways. First, intellectual property is intangible. Wait, maybe you're thinking, did you not just state that copyright is automatic so long as it's fixed in a tangible form of expression? I did, and this is one of the limitations of copyright and other protected intellectual property. If you were to dream up a musical, literary, or artistic work, that alone is not enough to establish ownership. If you're to claim ownership of something, it must be recorded in some way. The same is true of inventions as well as words, phrases, symbols, and designs. Second, intellectual property is also different from other property, and that is indivisible. This means that it can be divided infinitely without being depleted. That math is not math, so we say it is indivisible. But just because it is indivisible does not mean you cannot steal intellectual property, and though it cannot be depleted, it can be diminished. Imagine you were to write and record a song. If another recording artist records the same song and it sounds substantially the same, it seems likely that the original version will have less value. When we talk about intellectual property protected by the law, there are four primary types: patents, trade secrets, trademarks, and copyrights. Patents can be further divided into four primary categories. There are process, utility, design, and biological patents. Each of these covers a unique situation, but the steps to gain a patent and the restrictions to what is patentable encompass all types. I will get into those in the next section. Things that fall under the protection of patents, like processes, utilities, and unique biologies, may alternatively be covered by intellectual property law related to trade secrets if they're not made publicly known or available. Trademarks are used to differentiate brands or products and are covered under unique intellectual property laws in and of themselves. Finally, copyright is broadly encompassing of intellectual property rights not covered under the aforementioned types of intellectual property. Copyright covers everything from creative works to code to representations of facts. You might be asking yourself, why should I care about these things? First, you have rights. You have rights to your own work and likely have a vested interest in protecting those rights. You also have certain rights that may cover your use of others' works. Additionally, others have rights too, and there can be civil or criminal penalties for violating others' intellectual property rights. The same laws that protect you in certain use cases of others' works also protect others' use of your works. For the purposes of this lesson, I have grouped patents, trade secrets, and trademarks into the next section, and reserved the final section for copyright. My rationale for spending additional time on copyright is that I believe copyright is more likely to be broadly relevant to you as students. You all hold copyrights and will likely develop more copyrightable things throughout your careers than patents, trademarks, and trade secrets. Copyright is also more broadly present as an automatically protected class of intellectual property. Next up, I have a guided activity where I ask that you find a patent, a trademark, and a copyrighted work. I suspect you've all seen trademarks and copyrighted works, but you may be less familiar with patents. Patents can also be a little tricky to find, but there are tools to help you with searching patents.